before we rest, we would ask that this be marked as State's Exhibit 3.
2 has not been admitted.
No, and then, well, we would, I think she was just using that as a demonstrative
Okay,
exhibit.
that's fine.
We would ask that this be marked as State's Exhibit 3. This is the transcript of the jail call from May 8th, 2023.
Okay. Thank you. Brittany, will you put 3 on that? Ms. Lazaro, any objection to admission of State's Exhibit 3 solely for the purpose of this detention hearing?
Not necessarily, I mean, only to the extent that I have not been provided a copy of any of the jail phone calls that I could find last night when I was searching.
Do you have any of the audio?
No, that have been provided in discovery. So,
All right.
I don't know what to do with that.
Well,
So I guess,
out of
yes,
fundamental
I would object.
fairness for the defendant, and without having to address the need to postpone or continue this detention hearing, I am not going to consider that phone call. State's Exhibit 1 is in. State's Exhibit 3, for the purposes of this detention hearing, is not.
Okay.
Okay.
And Your Honor, we have no further witnesses. However, we do have a victim impact statement from the victim representative.
And if you could just name that person for us.
That's Amy Richards.
Amy, if you don't mind stepping forward to the podium. Good morning. Go ahead.
Dear Judge Mrazik, I'm here today to represent my brother, Eric Eugene Richens, whose life was taken in a senseless act of poisoning on March 3rd, 2022. His wife, the defendant, has been accused of committing this crime. If she is found guilty, she has committed the ultimate act of betrayal. Eric is gone, and I am brokenhearted. He was my best friend and protector. The feeling of loss is so great it is visceral. And with the sorrow comes a wave of panic at not being able to see him again. I can never talk to him, never hug him again, and never more be a part of his life. Eric's world revolved around his family, his love for hunting, the family cattle ranch, and his intense drive as a successful entrepreneur. Being born into the Richens legacy shaped Eric's formative years and resulted in a lifetime of hard work, dedication, and fierce loyalty. At an early age, Eric learned the joys of keeping horses and cows around. He spent countless hours helping our dad work the ranch, hauling hay, feeding the animals, and mending fences. He loved our family unconditionally and was a devoted son, brother, uncle, and father. Eric was a family man who always strove to be the absolute best father and husband. He was an attentive and loving father to his 3 sons and a devoted husband to his wife of almost 9 years, Corey, the defendant. Eric did absolutely everything in his power to provide his family and his 3 sons with every possible opportunity to learn, grow, and have fun. He was the coach or assistant coach on all his boys' teams, which included soccer, basketball, and baseball. He spent countless hours coaching and teaching the boys to play aggressive and give it their all. Eric truly cared about every single child he coached and wanted the absolute best for all of them. There was never a dull moment when you were around Eric, whether it was him showing up to a family dinner with no socks or the sleeves torn off of his shirt because he had to make an emergency bathroom stop along the way, or his calling to tell you he rolled the 4-wheeler for the upteenth time is stuck and he needs you to come get him. It was never boring. Eric loved to have fun and always wanted to make sure everyone else did as well. He owned almost every motorized toy possible, from 4-wheelers and side-by-sides to trucks and snowmobiles, and was so excited to share those with his sons. He had the perfect combination of business sense and foresight. He built a very successful masonry business from the ground up and helped many friends do the same. He had a special ability to build close relationships with everyone he worked with, which really allowed his business to thrive. Eric loved every aspect of his job, but most of all, he loved the people he worked for and those he worked with. Eric faithfully supported organizations that he truly believed in. He never was one that wanted recognition or accolades. He did most things anonymously and without recognition. Eric was a true champion of all people. It did not matter if you were an employee, friend, family, or the next random person walking down the street. If you needed anything, you could count on him. He truly cared about each person he met. Eric loved fully, laughed loudly, and lived life with reckless abandon. He enjoyed great adventures to far-off places, but also cherished the small and finer things in life. No obstacle was too great for Eric. He simply viewed each one as a challenge. No peak was too high, and the next adventure was always just around the next bend. Words cannot describe the loneliness and loss that is felt in every heart that was lucky enough to know him. Eric was such an inspiration and role model for us all. His loss has created a Grand Canyon-sized hole in this community. Except instead of taking millions of years to slowly form, our worlds change overnight. His 3 boys' entire worlds and their perspectives on life changed. None of our lives will ever be the same. Eric died under horrendous circumstances. I am tormented at the thought of what he endured. I play it out in my mind. I go through the terrible sequence of events. I wonder when he realized he was in mortal danger. I wonder what Corey may have said to him in his last moments. How long was he conscious, knowing he would die? Where were Eric's boys when all of this happened? Did they hear Eric's body fall to the ground? Did they catch a glimpse of their father taking his last breath? It's torture to think of. Why did Eric lose his life? Why did the boys lose their father? Was it because of Corey's greed and desire to get life insurance and other assets? If so, that is abhorrent. How could anyone value human life so cheaply? I cannot comprehend it. I'm overflowing with grief and pain at the thought that Eric meant so little to her. If Eric had died because of an illness, he would have been cared for. He could have looked after him and been with him. If he had died because of an accident, people would have tried to help. There would have been kindness. But there's no comfort to be had here. There's no consoling thought in the way Eric died. In his last moments, after being intentionally poisoned, he was faced with betrayal and terror. The thought of it is unbearable. I am haunted by the horror of it. This last year has been a living hell for our family. We have watched as Corey has paraded around portraying herself as a grieving widow and victim while trying to profit from the death of my brother. Both by trying to profit from a book about his death and trying to get life insurance and assets that should go exactly where Eric wanted them to his boys. Immediately after Eric was killed, Corey told us she could not help us get anything ready for the funeral as she was too distraught with grief. We shortly found out that was not true at all. In fact, she pulled herself together enough to go close on the purchase of a $2 million home, hire a real estate agent, hire an architect to create CAD drawings of the home, hire a lawyer in order to file a lawsuit on Eric's trust, hire a locksmith to come break into and clean out my brother's safe, and attempt to have Eric cremated. She mustered up the strength and resolve to do most of this within 48 hours of his death. Corey assaulted me. I will never forget the look in her eyes when she attacked me that Sunday morning. It was early and had been snowing most of the night. I was just getting ready to leave and heading out to the car when I saw a locksmith in Eric's detached garage starting to drill out his gun safe. I asked Corey multiple times why we could not just call my dad for the code. I could not understand why she was breaking into and ruining Eric's safe. To this, she screamed at me at the top of her lungs, called me some inappropriate things I cannot share with you here, and then told me to get out of her house. It was then that I told her that she could not kick me out of my brother's house. My sister Katie was now the executor of Eric's trust and estate, and just like Eric, she would not want the defendant breaking into his gun safe. Corey looked at me with pure hatred and rage. I was messing up her plan. I was getting in her way, and because of that, she attacked me. She punched me in the face and neck multiple times. It took 4 people to pull her off me that day. Before the funeral, Corey opened a bank account and asked everyone that was grieving to send her money instead of sending the family cards and flowers. It was not even 2 weeks after Eric's passing that we were told she had taken down all but one photo of my brother and removed all his clothing from the house. Corey put together a golf tournament in Eric's name 2 months after his death on what would have been his 40th birthday and told his family, all of us, that we were not allowed to attend. Since Eric's death, it has come to our attention that Corey took out multiple life insurance policies on Eric without his knowledge. It appears that she forged his signature on various documents, assigned herself as Eric's durable power of attorney, inappropriately diverted money from his business to herself, and assigned herself as beneficiary of Eric's portion of our mother's retirement account. I should also not forget to mention the multiple life insurances she has taken out on the boys. Her most recent business venture was authoring a children's book about how to help grieving children cope with the loss of the death of a parent. In this book, she had the audacity to use the boys' real names and even use their last family portrait. Her behavior gives me great concern, as she has exploited the boys for money and will likely do so again. In addition, Corey has weaponized Eric's children, manipulating my dad to do or not do things by threatening to cut him out of their lives if he did not capitulate to her demands. She similarly deprived the boys of contact with myself, my sister, and her daughters, unless we agreed to give her the money in Eric's trust. Money that Eric wanted to go to his 3 children. As if that were not enough, I have been told that Corey started telling their 3 little boys that none of Eric's family or friends loved them. She apparently told them none of us cared for them or wanted to be around them, even though that is the exact opposite of what was happening. We all want nothing more than to be there for those 3 little boys, my nephews, yet Corey has made sure to cut us out of every aspect of their lives. This is all just a brief summary and the start of what our family has been through over the last year. We have scarcely gone a day without finding out some new allegations or evidence regarding something Corey appears to have maliciously done to attack and undermine my brother, his 3 little boys, and our family. We have all been there since the beginning of Corey's and Eric's relationship. I was there on one of their first dates. We were there at the wedding. We were there when each of the boys were born. We have been there for every birthday party, school graduation, and rodeo. We welcomed her into our family and treated her as one of us. Not only did she betray our brother, it feels as though she has murdered and taken away a part of our souls as well. Because of her actions, there has not been a day that has gone by we have not lived with paralyzing anxiety and fear, worrying for the boys' lives as well as our own. I may be naive, but I never knew evil like this existed. If Corey was in fact willing to kill Eric for money, who's to say that what she will not do? Who would be next? Corey was in a desperate financial situation when Eric was killed, and that situation seems even worse now. We understand that she has defaulted on loans and is already a defendant in other lawsuits based on her financial misdeeds. I am truly concerned that she will stop at nothing to dig her way out of the problems, including murder. She seems devoid of moral sensibility, and there is no telling what she will do if she is released. Judge Mrazik, her fate lies in your hands. Please do not allow Corey to use the fraudulent life insurance proceeds to get out on bail. That would be morally reprehensible. Please do not allow Corey to take advantage and make a mockery of our justice and legal system anymore. She has done enough. Please do not allow Corey to hurt Eric's memory, our family, friends, and community anymore. We have been through enough. Please do not give Corey the opportunity to hurt Eric's 3 boys anymore. They have lost enough and have been through enough. Since Eric's death, we have learned and unfortunately are continually reminded that Corey is desperate, greedy, and extremely manipulative. If she gets out on bail, I will be afraid not only for my own life and those of all of my family, but most importantly for the lives of Eric's 3 sons. Our family has already suffered enough. Please do not let Corey out on bail where she will be a risk to do further harm. Please protect what Eric put his life on the line for, his 3 boys. Thank you.
Amy, thank you. Ms. Cassell?
Nothing further, Your Honor.
Okay. Ms. Lazaro, is the defense calling any witnesses?
I am not. I guess what I'd like to do is just largely have the court review the briefing and the attached exhibits be submitted and considered as part of this, but I don't intend to put on any further evidence.
All right. Would you like an opportunity to make any closing argument for today, Ms. Lazaro?
Yes.
Why don't we have defense go first, and we'll just give the state the last word?
Thank you, Your Honor.
Okay.
I guess I'd start with whether or not the court has any specific issues they would like me to address.
No, I mean, candidly, there's a threshold legal issue here, right, that comes out of the briefing, and the state has been candid about the pending Barnett case. I listened to the oral arguments
Correct.
before the Supreme
Right.
Court. I think the state is wise to request a ruling in the alternative, but I'm persuaded by the defendant's position that as a matter of law, while a defendant charged with a capital felony supported by substantial evidence does not have a right to bail, they can nonetheless request bail, and the district court retains discretion, at least under the current status of the Utah Code, to consider the request. So fast forward past that.
I will do so. And don't necessarily disagree with what may or may come out of that case that's up on appeal.
Right.
With regard to the sufficiency of the evidence, I mean, we're here because of a really tragic circumstance, and I don't think any of us want to forget that. I mean, especially my client. She loved her kids, she loved her husband, but she's also charged now with his murder. And so I just don't necessarily want that to get lost on the court, that we understand the gravity of the situation. With regard to the evidence, I'm gonna skip through most of it. I think the most important thing, if she poisoned him, is did she ever get it from CL? Was it ever requested from CL? I don't think the state has been able to draw that nexus. I don't disagree that CL was buying drugs. I think that's clear. She has a history of being a drug distributor. She was jammed up on 4 first-degree felonies. She had a potential federal case hanging over her, and then when they look at her phone, they find evidence of additional drug distribution as an entirely new charge. Pursuant to essentially the detective's testimony, is they walked her down the line of, I need more evidence, this is what we need to know, and provided evidence to her essentially until she got it right, and then she was released. When we look at the cell phone mapping, yes, we know that she went and picked up a check, we know that she was cleaning houses, we know she cashed a check, we know she picked up drugs, but they can't put her anywhere in the same vicinity of Corey's phone. Because apparently the mapping's not available from Verizon, which somewhat surprises me, given it's Verizon.
I think it's a length
But-
of time between the events and the request.
Correct. But they have corroborating evidence for all the things about her buying and selling fentanyl. They have zero corroborating evidence for anything related to Corey requesting it, her giving it to Corey. She didn't tell anybody that she was buying it for Corey. She never had anybody with her when she dropped it off. There's nothing to make the most important correlation in this, and that's that it was ever provided to Corey, that Corey ever requested it. There was no fentanyl or traces of fentanyl found in the home anywhere. And I think that's significant. I think if she had gotten 30 pills on at least 2 separate occasions, that's a lot of fentanyl. I mean, if one's lethal, all right? We're talking about a lot of fentanyl, and nothing is found, no traces anywhere, absolutely nothing. So I think the state's making a big leap in their evidence by saying, look, we have this girl, we know she's a drug dealer, we know she's buying fentanyl, but there's nothing to corroborate anything she says that ties it to Corey. The glass, Corey tells them she made him a drink, right? The glass is there. No one thinks to bother to.
Where's the evidence that the glass is present?
Well, they didn't look for a glass, I guess is what I should say.
Okay.
So no glass was tested. So there's nothing to show that Corey did anything to Eric. And by Detective O'Driscoll's testimony, it could have been accidental. I mean, it very well could have. And I think that, given the evidence presented today, is a very plausible situation. Being bad with money does not make you a murderer. Being bad at managing your accounts, makes you bad at math, but it doesn't make you a murderer. The other thing I think that's significant is by the testimony that came out today, the hard money loans that she owed, at least, far exceeded life insurance policy that was paid. And so even getting the life insurance money was not going to solve Corey's problems, not even close to solving her problems. And so that evidence alone, while, maybe there's some other issues with Corey's business, there's nothing to tie it to her having any motive or in any way being in a better position from Eric's death. In fact, she's in a worse position because of his death, because Eric had a business. He was continually making money. He was, from what it sounds like, the one putting the majority of the contributions into the joint account. So his death, from a financial perspective, has harmed her far more than any money that she gained from any life insurance. With that, I'll largely submit on the remainder of our briefing, as I trust the court has been through it all.
I have, carefully. Thank you.
Thank you.
Ms. Cassell.
Thank you, Your Honor. With respect to the no corroborating evidence, there's a lot of corroborating evidence that corroborates CL's statements. And I think one of the things that we have that's said is, that she was primed and told what to say. But what really happened is she's, a year later, she's asked to consider what, if she remembered anything else, and she came back with, yeah, I remember more, and that's very typical of witnesses. It's typical of people that we have testify. And then just you heard all of the corroborating evidence, Your Honor, the matching with the cell phone records, matching with the mapping. Do we have CL putting the drugs in Corey's hands? We do. We have a hand-to-hand that was testified to. So we have the evidence that Corey got, or the defendant got the drugs. We also have the evidence that corroborates all or most of CL's story. We would have more if there weren't texts that were deleted. We have a great deal of information that was deleted, and that was deleted off of the defendant's phone. So I think that is sufficient evidence just for CL, and that makes CL credible. This idea that no glass was tested, well, if you look at the pictures that we have submitted, there's nothing there. It's a stage scene. How they can argue that Eric somehow consumed this himself? There's no glass, there's no baggies, there's nothing there that indicates that this was ever taken, the fentanyl was ever taken by Eric. And also to say it's accidental, 1 or 2 pills might be accidental. 20 or 5 times the lethal dose is not accidental, Your Honor. That is someone who wants Eric dead. And the person who benefited the most from Eric being dead is the defendant, or the person who thought she was going to benefit the most from Eric being dead is the defendant. She thought she was going to be entitled to Eric's estate. She didn't know that there was this trust that had put the money into Katie Richens' name, so she's the one that thought on the day that Eric died that she was the one that was going to benefit. She benefited from the insurance policies, she thought she was going to benefit from more, and she thought she was going to benefit from Eric's estate. She tried to benefit from the other life insurance policy on Eric's business. That didn't happen. She also was in dire financial straits, Your Honor, writing checks on closed accounts or checks with no money in them. I know you cut me off, but that's significant.
It was in
because-
your brief, I got it.
I thank you. I understand. But that's significant because she was in dire financial straits. She was deep in debt, and the way to get out of that debt was to kill Eric Richens. She benefited financially, and she had many cases, and we talk about this all the time, prosecutors say we don't need motive. This case has motive. This case has motive that she needed to get out of this debt, and that's the reason she killed Eric, in hopes of getting his estate, in hopes of getting his life insurance policies, and that, Your Honor, we believe is substantial evidence.
All right. The issue before the court is whether defendant Corey Richens should continue to be held without bail during the pretrial period. Defendant is charged, among other crimes, with aggravated murder under Utah Code 76-5202 sub 2. To convict defendant of this charge, the state must prove beyond a reasonable doubt at trial that defendant intentionally or knowingly caused the death of another individual under any one of the following circumstances: for pecuniary gain, or by means of the administration of a poison or of any lethal substance. Under Article 1, Section 8 of the Utah Constitution, a defendant charged with a capital offense has no right to bail if there is substantial evidence to support the capital charge. And under Utah Code 7720-201 sub 3, a charge of aggravated murder is considered a capital felony for the purposes of determining bail during the period before the state makes an election whether to file a notice of intent to seek the death penalty. Accordingly, at this time, the aggravated murder charge in this case is considered a capital felony. Moving to the substantial evidence inquiry, having considered the evidence offered by the parties, both through live testimony today and by documents attached to their briefs, which the court has reviewed at length, and having had the opportunity to weigh the credibility of that evidence, the court determines the state's evidence, notwithstanding contradiction by defendant's evidence or arguments, could support a reasonable jury reaching a guilty verdict on the charge of aggravated murder. Indeed, a jury could reasonably choose to rely on the state's evidence regarding means and motive and consciousness of guilt, which includes evidence showing that Eric Richens died of fentanyl ingestion, that he was not known to be a user of illicit drugs other than the occasional THC gummy, that defendant purchased 15 to 30 fentanyl pills from CL approximately 1 month prior to Eric Richens' death. Cell phone mapping confirms, or at least indicates to a reasonable jury, that CL's phone was near the Maverick and Draper on February 11th, and that while there, CL's phone made calls to acquaintances, capital A acquaintances as listed in the testimony and the information, and sent texts to defendant Corey Richens, and that CL's phone then traveled to Francis and then was in Francis and then returned to Heber. We have CL's sworn testimony that she handed the fentanyl that she acquired to Corey Richens in a hand-to-hand transaction in her driveway. We also have motive. At the time of Eric's death, defendant knew how the premarital agreement would operate, but was not aware that Eric had changed his estate plan. So at the time of Eric's death, defendant's subjective understanding was that she would get a greater share of the marital estate if Eric died during the marriage, as opposed to what she would receive under the premarital agreement if the parties divorced. Moreover, evidence admitted in the case shows that in the months leading to Eric's death, defendant's personal and business accounts were overdrawn. She was making significant recurring debt payments, many of which were to hard money lenders, and that her lines of credit or lines of credit available to her were maxed out. And at the time of his death, Eric's life was insured for approximately $1.2 million, not including the policy related to the buy-sell agreement, with defendant listed as the beneficiary. Moreover, we have evidence from which a jury could reasonably infer consciousness of guilt. We have evidence regarding the search history that was extracted from defendant's second phone after her first phone was seized. And then we have inconsistent statements made by defendant as compared to other evidence in the case regarding whether she called 911 immediately, whether she performed CPR, whether she did something else for the 15 minutes between discovering Eric dead and calling 911. In considering this evidence, a jury could reasonably choose to discount and find unpersuasive defendant's efforts to poke holes in the state's case, and in so doing, a reasonable jury could reach a verdict of guilty beyond a reasonable doubt on the charge of aggravated murder based on the state's evidence. For these reasons, the court determines there is substantial evidence to support the capital felony charge of aggravated murder against the defendant in this case. Having made that determination, the court considers whether it has discretion to grant defendant bail, notwithstanding that she has no right to bail under Article 1, Section 8 of the Utah Constitution. And having considered the arguments and authorities cited in the parties' briefing, the court determines as a matter of law that in the case of a capital felony that is supported by substantial evidence, while a defendant does not have a right to bail, the defendant may nonetheless still request bail, and the district court has discretion to grant bail if the circumstances warrant doing so. But the circumstances of this case weigh soundly against granting pretrial release of any kind. First, defendant is charged with aggravated murder, which carries the possibility of sentences as severe as the death penalty and no less severe than an indeterminate prison term of 25 years to life. The severity of those sanctions, the severity of the sanctions that follow a conviction for aggravated murder creates a powerful incentive for a defendant to resort to desperate acts that might include harming themselves, harming the members of their family, or harming witnesses in the case. Because an incentive this powerful cannot be adequately managed in the community, it weighs heavily against granting any form of pretrial release. Second, the state has offered substantial evidence that defendant procured fentanyl on more than one occasion, and on at least one occasion deployed that fentanyl to cause the death of another person. As a general matter, an individual who is capable of this kind of decision-making is not a good candidate for supervision in the community. More specifically, given the uniquely dangerous nature of fentanyl, which has been demonstrated tragically by events in Summit County, defendant's alleged conduct, as supported by substantial evidence, is especially dangerous. Indeed, these circumstances constitute clear and convincing evidence that defendant would pose a substantial danger to the community if released on bail, a substantial danger that cannot be adequately managed by any combination of conditions of pretrial release that are available in Summit County. For these reasons, the court finds the circumstances of this case, as supported by substantial evidence, weigh soundly against any form of pretrial release. The state's motion for pretrial detention is granted. Defendant Corey Darden Richens shall continue to be detained without bail during the time she awaits trial or other resolution of the criminal charges against her. Ms. Richens, you have the right to an expedited appeal of the court's ruling today. You must file a notice of appeal within 30 days of the court's ruling, and you have the right to be represented by counsel on that appeal. Let's pause there for a moment. Ms. Cassell, any questions?
No, Your Honor, thank you.
Ms. Lazara,
No, Your Honor, thank you.
where do we go from here? Are you prepared to set a preliminary hearing?
I don't think so, because I think just based on the state's briefing and evidence provided, there's a lot of stuff that I don't have yet. And probably need experts to look at, especially with regard to the phones.
Okay. What is a reasonable time to set a scheduling conference, understanding that I'm going to push counsel to move this case as fast as possible, given that Ms. Richens is in custody?
I understand that and appreciate it. I guess that question should be posed to the state as to when they think they can get me things. Like, I can't prepare without the evidence. I'm at their mercy at this point.
Can we check in on the 26th, just so you can tell me whether you think you've received everything the state has?
I will, yes.
Do you want to do it in the morning or the afternoon?
Let me look.
26th of June?
Yeah. Oh, you know what? I'm looking at the wrong, I'm
Mark,
sorry.
That's a Monday, Your Honor.
You're right. You know what, though? That's probably okay. Let me take a look here, folks. 1 second. What's that? You're right. That's not going to work. Okay.
Can we do it the 23rd, Your Honor?
We can. Can you get stuff turned around that quickly, Ms. Cassell?
Well, we.
You believe you've given it all.
We have, yeah,
Okay.
we have everything that we have, we put in our.
Well, we're going to find out. June 23, Ms. Lazara?
I'm out of town as long as I can appear via WebEx.
It's fine.
And I don't know that we need Ms. Richens if we're just gonna set it as a status.
But she has a right. She doesn't have to be in the courtroom if she doesn't want to be.
Can we do it the 30th instead then, so I
We
can?
can't. I'll be out of town. You want to go to the 7th?
No. I can't cancel the 23rd. Like, that can't happen.
We can also special set it.
I'm sorry, what else do you have?
No, it's fine. Do you want to do midday on the 22nd?
Yes.
Ms. Cassell?
That's fine.
All right, noon on June 22 for a scheduling conference. Would you like that to be by WebEx, Ms. Lazar?
No, I can come in person.
All right,
That's fine.
very good. June 22 at noon in person here in courtroom B. Ms. Lazaro, anything else on the record today?
No, I don't have anything further, thank you.
Ms. Cassell?
No, Your Honor, thank you.
All right, ladies and gentlemen, we're going to do this in an orderly fashion, and we're going to do it in stages. I appreciate your patience. Just listen to the deputies. Everybody in front of the bar, sit tight. The deputies are going to clear the gallery one section at a time first. Please just sit quietly and let them do their job. Thank you.
Your Honor.